We have, I'll go from right to left on this occasion, we have Shami Chakrabarti, Director of Liberty for 9 years, barrister by background, Chancellor of Oxford Brookes University, Governor of the British Film Institute, a visiting fellow of Nuffield College, Oxford, independent assessor on the Leveson Inquiry, and of course most famously now a flag bearer at the Olympics ceremony. One Olympian to another, of course, we have Sir Menzies Ming Campbell, who is also a Chancellor of a University, St Andrews, in Scotland, is also a lawyer as well, and of course needs no introduction as a very distinguished member of the Liberal Democrats. And then on my left here we have John Campner, who I'm afraid isn't an Olympian, isn't a lawyer, and isn't a Chancellor of the University yet, but there's still time on all those. He is, of course, an immensely distinguished campaigning journalist, a former editor of The New Statesman, author of a couple of fantastic books, which if you haven't read them I do recommend, Blair's Wars, and also one which, Freedom for Sale, How We Made Money and Lost Our Liberty. He was until recently Chief Executive of Index on Censorship, with which he's still closely involved, but he is also an external advisor to Google, and trying to make sure that they don't do evil in the future either, and promoting freedom of expression there. So there are panellists. It's going to be a usual format, other than the question which I mentioned earlier. So we're going to have 5 minutes or so of speeches from the panel, and then we'll turn the debate over to you and get as many questions in as we can on the important, vital topic facing us, holding their feet to the fire, civil liberties under the coalition. I guess many of us thought when the coalition was formed that civil liberties might be one of those areas where there could be a lot of common ground between Lib Dems and Conservatives. It's not necessarily turning out quite that way, with some big issues around secret courts, of course, which will be a big issue at the conference chamber this afternoon. The Internet Snoopers Charter, the draft Communications Data Bill coming up. We've got the extradition treaty, the lopsided extradition treaty between the UK and US, and of course the Conservatives' determination to overturn the Human Rights Act and install instead a British Bill of Rights. So lots of issues for us to be talking about this afternoon, and it's my great pleasure to introduce our first speaker, John Campner.
Thank you very much, Stephen. I think we've been asked to talk for 5 minutes and no more, so I'll just say a few points, a few bullet points, and then obviously throw it open to my colleagues and then answer any of the points that I've made or others have made in more detail in the Q&A session. Just first of all, the politics and the principle. The Liberal Democrats are a party of civil liberties, or they are nothing. It's fairly straightforward to me. On the principles of civil liberties, there can be no trimming on any of this. My last book, Freedom for Sale, and thank you, Steve, for the mention of it, is based around one rhetorical question, and it was this: why is it that increasing numbers of people around the world appear willing to give up their freedoms in return for the prospect of either security or prosperity? Now, that was published in 2009, and the prospect of prosperity may have receded somewhat for most people in this country and around the world, but the hankering after security remains exactly as it was. I'm not an absolutist, I'm not a purist. There is always going to be a balance, but my chapter, the book looks at 8 chapters, 4 authoritarian countries and 4 purported democracies. And I must say the chapter on the UK, looking at the record of the previous Conservative administrations and the previous Labour administrations, was the darkest of all the chapters. The record in this country was truly shocking. So therefore, a party that advocates civil liberties at its core, and did so in opposition, coming into a coalition, irrespective of the colour of the party it's in coalition with, was for me a source of great hope and optimism. The Protection of Freedoms Act was a very good thing. the removal of the threat of ID cards and DNA database was something to be celebrated. Libel reform, the Defamation Act. In my previous incarnation as running Index on Censorship, we were very much at the forefront of this campaign. We, along with one or two other groups, set up the libel reform campaign, and at the risk of blowing our own trumpet, we took on the entire might of the legal establishment, of Whitehall, and of others who basically thought we cannot turn this around. Britain's, or English to be more precise, English libel law was so deeply shocking that people, whether they were oligarchs or Saudi sheikhs or whatever, would come to Britain to sue others, third country nationals as well as Brits, in English courts because we were so indulgent. London was called a town called Sue, and the Obama administration was so deeply shocked through a couple of pieces of case law at what was happening to the freedom of expression of American authors and others, that it enacted the Speech Act, which is to protect American citizens from British courts and the humiliation, and that was the term that the DCMS Select Committee used in its report, the humiliation of having our closest ally in times of war and peace having to enact legislation to protect its citizens from our courts was something to behold. The Defamation Act is now going through, shortly going through the Lords, having been through the Commons. One should never make the great the enemy of the good. However, it's deficient still in 2 or 3 crucial areas. I'm cautiously optimistic that we can beef it up and we can produce a bill that significantly improves the situation, albeit not to the extent that one would wish. That's the good news. The bad news, and I'll defer to Shami and to Ming to talk about the Security and Justice Bill and the debate this afternoon, but I have very strong views on that. The other element, which is something obviously closer in my freedom of expression and Google advisory role, the Data Communications, the Snoopers Charter. It is a truly, truly shocking piece of legislation. There may be 1 or 2 elements of where technology advances and then already these security services legitimately have the right to request of communication service providers specific pieces of information, specific pieces of access where they believe the absence of that access could lead to real and present danger, either of an individual, that could be suicide, or more likely a terrorist attack or another act of serious violence and the prospect of death. In those areas, the companies do cooperate, and it's entirely right to do so. The plan, however, for a 1-year trawl, a massive data dump of everything, of every single person. They try to distinguish between content and contact, and they may not look in the 3rd line of your email, but they will have, if this goes through, access to the information on every single email, every single tweet, every single direct message, every single piece of communication that you make with everybody else, just in case. So imagine all your refuse over the last year, everything you chuck in the bin or recycle that you have to keep for a year, just in case something you have done or said could lead to serious criminality. It beggars belief. It's an astonishingly broadly, vaguely and badly drafted piece of legislation, and it is absolutely incumbent on the Liberal Democrat part of the coalition to ensure that, albeit there may be, as I say, through a very, very tight drafting of a clause or two standalone piece of technical amendment allowing the existing parameters to be extended to other forms of technological communication, but that is extremely narrow. It is nothing. It is a million miles away from what is being currently proposed. So I would say to Liberal Democrats in government, look at the detail of what is proposed in these bills. Look at the practice too. Don't allow ministers to fall in that old trap that Conservatives and Labour willingly did, which is the spooks come into the office and they say, Minister, if only you knew what we knew, be afraid, be very afraid. And I'm afraid it's one of those baubles of government. People get a little bit tickled by the idea that, you know, I'm now privy to seriously sensitive documentation. Show a far deeper, a greater sense of, obviously, listen, obviously be aware that, you know, there is ongoing and serious terrorism and organised criminal threat, but just be cautious in your dealings. And finally, just remember the principles. Remember why you are Liberal Democrats. And just look at the politics of all of this. Neither Labour nor the Conservatives have covered themselves in glory over the last 2 decades in terms of their civil liberties credentials. They are predominantly and quite unapologetically largely advocates of authoritarian measures when it comes to criminal justice. There is an enormous amount of political space and goodwill and scope. There is a unique selling point in continuing to be in government, which is much harder, as it was in opposition, where one could hide behind rhetoric. Just remember, in government, it's just as important to stick by those original principles. Thank you.
Thank you, John. I've seen people have been waving their question sheets, so if you've been filling one in whilst John's been speaking, do wave it now, and there'll be people who are on hand to collect them. And now, over to Ming Campbell.
Like one or two of you here, I'm a refugee from the old Liberal Party. The idea that the audience would have to submit its questions to the chair, so the chair could sift out which questions could be asked, would have produced a reference back, a suspension of standing order, and the mass resignation of the conference committee. Those are the days of civil liberties, I can tell you. If you walk past the conference centre here, if you'd never been a Liberal, if you'd never had anything to do with a political body, you could walk in and vote on behalf or against the government's, the party's policy on nuclear weapons or any other thing that took your fancy. So life has changed. I'm going to begin with my mitigation, because when I come and talk about the Justice and Security Bill, I suspect I'm not going to make many friends, but I shall do my best to explain why that is. First of all, John Kampfnout gives us a reasonable report card on issues like identity cards, detention without charge, DNA database, things of that kind. And I'd like to say a word about extradition, because that's an area I've tried to concentrate on largely at Nick's insistence. I've written a review of the present position, which I've submitted to Nick. It's still I don't think it's gone into an obscure pigeonhole in the Deputy Prime Minister's office. But it's now available to him, and advertisement, I wrote an op-ed for the Observer a week ago on Sunday, which I think is probably still available. 2 particular issues on extradition. The standard of proof required before extradition can be effected. You probably know the United States, 4th Amendment to the Constitution, probable cause is necessary. So far as the legislation enacted by the Labour government, which David Blunkett now seems to be rather less supportive of than he was at the time, reasonable suspicion. If you're a lawyer it's easy to suspect someone may be guilty of a crime. It's something rather different, it seems to me, to say that someone is probably guilty of a crime. And so I think there's a real issue there. There's also an issue of what is sometimes called forum bar, when an criminal action has taken place in one jurisdiction but with consequences in another. Then if a decision is made to take it in one place rather than the other, then that should be the subject of a fully transparent process. Then court should not be something left to the discretion even of the wise Director of Public Prosecutions. It should be a judicial decision. On communications, I agree entirely with what John has said. I mean, I have a rather old-fashioned view about privacy, and the privacy of the kind we're talking about, particularly in the wake of the information technology explosion, should never be interfered with unless on a warrant. I'm old-fashioned about this, and perhaps because I'm a lawyer, and some may say this later, I rely too much on judges. But by and large, we've got pretty good judges in this country, both north and south of the border. Remember, separate legal system in Scotland and the system in England and Wales. And I think if you want to know what I said in my email to my wife 6 months ago for some purpose, you have to go to a court with a warrant and to satisfy the judge that that is a legitimate interference in my privacy. And if you can't, I've been getting my mitigation in first, not the usual practice in legal cases. One other thing I want to say, I want to congratulate you on two things: getting here without resort to oxygen, and the second, to have resisted the blandishments of yet another fringe meeting, two former party leaders in opposition. And this fringe meeting I'm about to tell you was arranged long before the decision was made that we would give up our ministerial positions in the Foreign Office or the Ministry of Defence. The Right Honourable Lord Ashdown of Norton Southampton is speaking at a debate entitled "Why Have the Liberal Democrats Given Up Foreign Policy?" Remarkable prescience, you may say, or perhaps just good luck. So you've resisted that temptation. I think it might be, let me put this, quite an amusing occasion. Right, justice and security. I don't subscribe to the view that if you only knew what passed across my desk, this is the Tony Blair view in particular about Iraq. I'm on the Intelligence Committee. We sign the Official Secrets Act. We regularly take evidence from the heads of the 3 security services. We visit their premises, and we, from time to time, have information about operational issues. I'm not tickled by that in any way whatsoever, but I do feel a sense of responsibility about it as to the proper scrutiny of it, and also the extent to which my actions or beliefs should be influenced by it. And just one other thing about the Justice and Security Bill before we get on to what you might call the meat. The proposals within the bill are to enhance the powers of the Intelligence and Security Committee, to make it now a select committee of Parliament rather than a committee exclusively appointed by the Prime Minister, and usually on the basis of what's called the usual channels. So if you've been around long enough, then somehow you qualify for membership of that committee, or indeed, under the previous administration, if you've been sacked as a minister, then your immediate first port of call was to become the chair of the Intelligence and Security Committee. Put it on an entirely different basis, and to provide in statutory terms something which has grown up, but which was never provided for in the original statute, that the committee may have regard to operational activities, not contemporaneously, but retrospectively. And that will enhance the responsibility of the Intelligence Committee. And my view is these things, there's a sort of gradualism about them. I believe that the increase and improvement in scrutiny which the proposals will provide will not be the end of the game. I think we will, over the piece, we will proceed further. One last point. The heads of the agencies have been talking about having open hearings. Now, there might be some difficulties about what you can and can't talk about at an open hearing, but the mere fact that that principle is being conceded or discussed seems to me to be a step in the right direction. Well, let me come to the Justice and Security Bill. And my attitude to this, and I think I tried to put it properly a moment or two ago, is not to be tickled, but to feel a sense of responsibility. I have sat in the offices of some of the intelligence agencies in the United States. They have 18, would you believe? 18 separate agencies, often with a lot of rivalry and overlapping, and also in the State Department too, and have been assured that following the implications of the Bin Mohammed case, then the nature of the transfer of evidence from the United States to the United Kingdom was altered. Now, why is that important? Because these two countries are the most important intelligence partnership that exists, perhaps, certainly at the moment, and probably even in the days of the Cold War. Now, when that information is given to you by what appear to be credible witnesses, you have to ask yourself, what consequence could that have for the United Kingdom? If there's not the free transfer of information, then is it possible that circumstances may arise where, in the absence of that information, damage was done either to property or to persons? Now, it can be said, well, they would say that, wouldn't they? Because they have, if you like, their own agenda. And therefore, it's a matter of judgment as to whether you accept or believe what you're told. But that seems to me to be an important issue to be taken into account in considering how we deal with the question of national security in the light of certain judicial proceedings. And in particular, what the bill proposes is that in relation to civil proceedings only, not criminal, nothing to do with life and liberty, but civil proceedings, seeking damages for using an illustration, improper detention, or perhaps it's argued a connivance in torture, that in those circumstances the government may apply to the court to ask the court, that's the judge, to determine that certain of that evidence may be heard in private. Because, so the argument would run, that to allow it to be heard in public would damage national security. Now, how could you damage national security? You could damage national security, for example, by revealing the identity of sources. You could even put the lives of people in that position at risk. You could damage national security by revealing the techniques by which intelligence is gathered. And that would mean that that technique, and remember, some of the people we're dealing with are just as clever as we are, if not cleverer, but that technique would no longer be effective. And you could also damage a contemporary operation by revealing information which allowed people to deduce from that what was happening and the extent to which the intelligence services in this country were across the risk to the rest of us. Now, it's highly controversial, and I start from this position, so there should be no doubt. And I hope I've illustrated that by my attitude towards the communications proposals. If you're going to detract from the ordinary principles of civil liberty, then the onus on those who wish to do so rests with them. It is the responsibility of those who want change to justify that change, and they're required to justify it by compelling evidence. And that's a responsibility I freely accept. And in my judgment, in these particular circumstances, I think that situation exists. And it's interesting to look at some of the observations which have been made. The Master of the Rolls, in a lecture in March last year, said, "Open justice can be set aside in narrowly defined circumstances." Now, I would wish that every proceeding that took place in every court was entirely open and transparent. But day and daily, judges have to deal with the question of admissibility, because that is part of their function. They're used to determining what evidence can or cannot be led at all. What these proposals provide is that all evidence will be available, but some of it will not be publicly available. Now, there are those who argue against that as a matter of principle. I don't expect Shami to agree with me. I fully respect her position. But I hope there will be a reciprocal respect for those who have taken a judgment of a different kind. Now, judging by the looks on some of the faces, I haven't made too many friends. Let me remind you of what the great George Carman QC once said. In an impossible case, he looked at the jury and he said, well, I don't suppose I'm going to change any of your minds, but perhaps I may be able to rearrange some of your prejudices.
Thank you, Ming. Final reminder about question sheets, and over to Shami.
Right, we were told 5 minutes each. I'll try and stick to that and be as succinct as I can. Firstly, it's a great pleasure to be here. Thanks for the kind words about the Olympics. What can I tell you? I went into training immediately after those 5 o'clock in the morning starts. It's a great pleasure to be here. Liberty, the National Council for Civil Liberties, as you know, is a cross-party, non-party organisation. And therefore we seek friends across the political spectrum and from amongst people who are non-aligned. But let's be clear that that for Liberal Democrats, civil liberties and fundamental rights and freedoms are a core bread and butter issue. They bind you together. That's not me saying that, that's not flattery. Peter Kellner of YouGov spoke at the Liberty Fringe last night and made the same observation based on polling. It's pretty obvious this is a core binding agent for Liberal Democrats, therefore it's not just another subject. And I think that I think it is interesting that whilst the coalition was inevitably flung together by parliamentary arithmetic and the financial crisis, I think the noble glue that was able to allow Liberal Democrats and Conservatives, after years of very authoritarian New Labour government, the noble glue that allowed them to march together with a bit of a song in their hearts was probably civil liberties, opposition to identity cards in particular, and great thanks from me for making that the iconic first piece of legislation of the coalition government. That was a wonderful, wonderful, principled and totemic step to take. And I agree with John in particular on the other things that have been very good news in relation to cutting back on some detention without charge, in relation to trying to rationalise the overbroad DNA database, libel reform for which he takes no small credit, and so on. I'm with you on all of those things. But we're talking about the future now, and holding their feet to the fire. That's the coalition in government. And so I have to be a little forward-looking as well as being congratulatory about the recent past. That's my job. Whoever you vote for, on occasion, the government gets in. I'm very grateful again to Liberal Democrats, not just for being for rights for freeborn Englishmen, but for being for human rights for human beings. And that is not something that is always shared by some in the other coalition party, in particular for being champions of the Human Rights Act, not trying to replace it with nationalistic rights for freeborn Englishmen or British rights, but human rights for human beings. Why? Because it's right, because we're all human, and why? Because this is a shrinking, interconnected world where we have to choose whether to be a national in one place on earth or to be a human being everywhere. Ask Gary McKinnon. He never left his home in Wood Green when he went as an Aspergic man looking for UFOs on the internet, and now faces summary extradition to the United States. I'm so glad that Ming is taking an interest in this. Both coalition parties opposed summary extradition in opposition, and Janice, Gary's mum, is still waiting for those promises to be honoured, and we're waiting for the Home Secretary's decision. Comms data, completely agree with what was said, particularly by John. I have no problem at all with proportionate, judicially warranted intrusions into people's privacy, including into my home. If you think that there is evidence there or contraband there or a kidnapped child there, of course you should be able to come into my home with a warrant, in an emergency without a warrant. But that's not what's being proposed by the Comms Data Bill. The draft bill is the equivalent of saying There should be no unwatched space on earth. Wherever there is privacy, by definition, there will be some criminality. Now, I understand that privacy can be a place where guilty people hide. I understand that some terrible crimes happen in people's domestic homes. But is that justification for putting a hidden camera and a hidden microphone into every domestic dwelling in the country, recording everybody's private activity just in case, as was suggested, so that years later we can go back and we can trawl through all that data to see if you should be a suspect, and to use modern profiling technology to decide who is a suspect on the basis of that great big data dump, as John put it. So I completely agree with Ming and with others on the comms data bill, but here's the rub. There's no deal to be done. There's no trade-off to be done between the comms data draft bill, which is very simple and very populist, leave us alone, oh snooping state. There's no trade-off to be done between that principled policy and principled opposition to turning civil courts into secret commissions in this country. And there, I'm afraid, with regret, I really must disagree with Ming. Not, I think, on principle per se, but because I think he's misunderstood the current law and what is proposed in this bill. With regret, Ming, that's how I've heard what's just been said. At the moment, inquests take place, like the 7/7 inquest. Civil litigation takes place, and ministers cannot point to a single case where national security has been compromised. Why? Because, like me, we trust our judges, and they do protect national security. But here's the thing, under the present law of public interest immunity, a judge decides not just whether national security has been engaged, but the balance between justice and national security. And crucially, if one side, the government, wants to keep something secret, the government cannot rely on that secret, that untested secret intelligence in serving its own case. That is what is being proposed by this bill. That as soon as a minister says national security has been engaged, as long as the judge agrees, yes, this is a national security case, then we go into secret session where one side, the government, gets to have a private chat with the judge. The judge is no longer a neutral referee. The judge is sitting in a locked court with the government and the government lawyers and the claimants. That could be a war widow, that could be a torture victim, and their lawyers and the public and the press are shut out. So it's a one-sided argument rather than an assessment by the judge that some secret material needs to be kept outside of court. That's the difference between the current law of public interest immunity, which I support, and this ironically titled Justice and Security bill that is proposed. And I'm sorry, Ming, you misstate or you misunderstand the bill and the current law. Judges are referees. They can be misled in a locked courtroom if there aren't two sides to the argument. And when people say, it's going to be okay, Shami, because the judge will look at the secret intelligence by himself. That's what Gordon Brown used to say about locking people up for 42 days. You cannot have a fair trial. You cannot have equality before the law in this or any country if you take judges into a room with one side only. And that is what is proposed. Ming says quite rightly, it is incumbent on those who want to make a change to make the case for it. The Joint Committee on Human Rights says there is no need to change the law, national security is protected. The special advocates who would have to make this system work, who currently do control orders and TPIMs and all the rest of it, they say that this is wrong and there's no case for it. And you know what, there were times under the last government when we had arguments about locking people up endlessly without charge or trial and house arrest and so on, where the argument against me from New Labour at the time was, Shami, this is all very well to be so principled, but the consequence of your argument may be that some dangerous people walk through when they should be detained and they should be deported. In this case, this is not about detention, this is not about deportation, this is just about embarrassment and occasionally some cash. This is the bill that the Securocrats would have written regardless of who won the general election. And you as Liberal Democrats should not allow yourselves to be implicated in that. Nobody walks free. This is just about sparing the spooks blushes. And it's not acceptable. The Binyan in the Binyan Mohammed case, nothing was revealed by the Master of the Rolls that hadn't already been revealed in the United States. And he said that this was about protecting embarrassment, not national security. Now, I hear what Ming says. If there are some Americans, it depends which one you speak to, who say that they will withdraw cooperation unless this bill is passed, I think they should be reminded that they are asking for a change in the law which they wouldn't stomach in their own system. Last night was generally taking the sort of Ming position, asking me not to be absolutist. But even Paddy said last night, if friends say they will withdraw cooperation because of our liberal principles, then the Lib Dem answer is a great big liberal raspberry. So that was what Paddy Ashdown said at the Liberty Fringe last night. So I'm asking all of you to hold their feet to the fire, to keep true to your principles in government as you did in opposition. And at 5 o'clock this afternoon, when that debate comes round, vote in favour of Joe Shaw's motion F41 and against amendment number 1.